Breaking news out of the United States Court of Appeals for the Fourth Circuit. Just heard oral argument en banc in front of the entire Fourth Circuit Court of Appeals in the Bianchi case dealing with Maryland's quote-unquote assault weapon ban. And it was exactly as I predicted. Absolutely 1,000% terrible for the Second Amendment. These judges, in my opinion, at least almost all of them that spoke, they frankly, in my view, should be auditioning for a role as a trial lawyer in like Better Call Saul or Matlock rather than sitting on a federal appeals court. That's how bad this argument was. Absolutely pathetic. They were grandstanding and filibustering and seemed to have no interest in understand the rule of law and the Second Amendment. Absolutely terrible argument, but don't worry. I predict this. We're aware of this. And, let us all carry on. But let me break it down for you when we get right back. They're really the lowlights of this terrible opinion. I should say terrible oral argument by the Fourth Circuit and Bianchi. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of many books, including Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. Get ready for a big announcement coming up very soon. I'm working on a new book cover right now. All right, folks, so terrible day for the Second Amendment, but not an unexpected day. The United States Court of Appeals for the Fourth Circuit, based in Richmond, Virginia, heard oral argument today involving Maryland's quote-unquote semi-automatic ban or assault weapon ban, AR-15 ban, and as I predicted, the Fourth Circuit Court of Appeals is not only hostile to the Second Amendment, they are partisan hacks, in my opinion. Specifically, they have no interest in applying the law. Now, I should be very clear. Not every judge on the Fourth Circuit is terrible when it comes to the Second Amendment. There are some judges that seem willing to follow the rule of law, but the majority, and certainly the majority of who spoke today during the oral argument, it was very difficult for me to know who was speaking because there was no video and I could hear it, but I could not really see it. So as a consequence, I don't really know exactly who was talking. I have a sense, but I don't want to say the wrong name. But overall, the people that spoke today, the judges that spoke today, did a grave disservice to the federal judiciary. And I'm not one for hyperbole. I speak my mind. I try to be an honest broker and tell you what I think is really going on here, the good and the bad and the ugly. It's not about rainbows and unicorns. And I will tell you, as predicted, the Fourth Circuit Court of Appeals was absolutely pathetic when it came to this oral argument. In fact, I've actually requested on X that maybe someone should actually time the amount of time that the judges spoke versus the amount of time the lawyer spoke to demonstrate that these judges seem a lot more interested in speaking and hearing themselves talk than actually trying to get information from the lawyers to try to get to the right outcome of the case and to write powerful, persuasive, and accurate opinions. Absolutely terrible. So anyway, to hit the highlights here, the bottom line is we're clearly going to lose this case to the U.S. Court of Appeals for the Fourth Circuit. We're going to lose in one of two ways. They're either going to simply rule on the merits to say that their Colby decision, the Colby versus Hogan decision, that said that because AR-15s are like M16 fully automatic machine guns, semi-automatic AR-15s can be banned because they're going to use those few words in the Heller case in 2008 from the Supreme Court that says that M16s and the like can be banned, and because AR-15s are like M16s, they can be banned. That was the holding of the Colby case. So the first part of this argument was to the lawyer for the Second Amendment was, did the Bruin decision in 2022 override the Colby decision that said that AR-15s are like M16s? And there seemed to be kind of a sense on the court that indeed the Colby decision was left undisturbed. Now, you know and I know that the Colby decision really got Heller wrong. Bruin only reaffirmed they got Heller wrong because remember, Bruin reaffirms the Heller decision like dozens and dozens of times. Nevertheless, the first thing is going to be, will the Fourth Circuit rule and say that Colby remains the law of the Fourth Circuit, and therefore that's it. That's all they have to do. There was also a sort of a discussion as to whether or not this court should remand this case back to the district court for more years of litigation as to whether or not AR-15s are quote-unquote in common use. There was some discussion about that. But when Maryland was asked, the Maryland lawyer was asked what they thought should happen, I give credit to the Maryland lawyer who I thought given his arguments, did a pretty good job on behalf of the government. He said that he thought that the Fourth Circuit should simply affirm the Maryland District Court's decision to uphold the assault weapon ban or the AR-15 ban and simply have the Fourth Circuit issue a decision that says under the Second Amendment, these are not protected, and affirm it based upon the fact that Colby is still the law of the Fourth Circuit and not send it back on remand. So Maryland clearly does not want to remand. They just want to win this outright. And by the way, my opinion is we want Maryland to win this case outright and for the Fourth Circuit to come out and just say unequivocally that AR-15s and semi-automatic rifles are not protected by the Second Amendment. That's exactly what we want the Fourth Circuit to say, because that gives the Second Amendment plaintiffs in the case a clear shot to go directly to the U.S. Supreme Court on a cert petition. And it's clear to me that the United States Supreme Court is going to have to step in and fix this problem of arms ban cases, because every lower court, granted these lower courts in California and Illinois and in Maryland/Virginia are in kind of bad jurisdictions for constitutional rights in the Second Amendment. But it's clear to me the faster the Second Amendment gets to the Supreme Court, the better it will be, because I do think if these cases are before the Supreme Court, we in the Second Amendment community will prevail in the Supreme Court. But it's pretty clear to me we're not going to prevail in any of these lower courts, especially these courts of appeals, because they're just not taking the Heller case seriously, and they don't want to rule for us, so they're looking for every conceivable way to get around it. Okay, so that's what's going to happen. We're clearly going to lose, and we're going to lose in either one of two ways. They're either going to reaffirm Colby and say that AR-15s are not protected, or they're going to send the case back for years of litigation in the district court to conduct discovery and information as to whether or not AR-15s are in common use, whatever that means, and so on. That's really, it's going to go one of those two different ways. We'll see what happens. A couple other interesting things about this case. One judge literally said, just to show you the ignorance, and again, I'm not prone to hyperbole, right? So I'm speaking my mind. This is not hyperbole. This is what I heard and what I truly believe. One judge came out and said that an AR-15 can fire 300 rounds a minute. 300 rounds a minute. Now, the judge was corrected by the Second Amendment attorney that says, well, really, the Army indicates it's 40 to 60 rounds a minute. It's not 300, but that's the kind of ignorance that the Second Amendment movement was confronting in this Fourth Circuit Court of Appeal argument today. But let us carry on. Then there was clear pushback on the common use test. There was clearly judges that refused to believe that the Supreme Court in Heller said that the historical standard is dangerous and unusual, and the burden of proof is on the government at the historical level of the plain text first, shift the burden to the government to come forth with the historical tradition of regulation, if any exists. It's clear that several of the judges on the Fourth Circuit clearly did not believe that the government's burden was to show that a particular weapon they want to ban is dangerous and unusual conjunctive test. There was all these crazy hypotheticals. I might have said to the court, say, well, those are very fun hypotheticals, but these are not binding hypotheticals. The Supreme Court has already dealt with these kinds of things in Heller. You simply have to apply Heller. I don't have to defend the uncommon use test or any of that stuff, because you are an inferior court under Article 3. You have to follow the law. Nevertheless, the Second Amendment lawyer did try to deal with some of these hypotheticals. So some of the hypotheticals involved, popular guns that became kind of unpopular, or popular guns that became dangerous because of defects. There were some hypotheticals about bazookas, some hypotheticals about tactical nuclear weapons. And again, well, if they're bearable arms, the rule is the rule. You figure out, number one, is it an arm? And the Supreme Court has clearly defined arms broadly as in the right of the people to keep and bear arms includes all arms, which the Heller case defined as anything that can be used offensively or defensively based on 18th century dictionaries at the time, right? And therefore, an arm is an arm. The good news is some of the judges made clear, they said, look, obviously an AR-15 is clearly an arm. You can't dispute that. And as a result, the burden shifts to the government to show they're not in common use. Some of the judges, I think one was Judge Niemeyer, but don't quote me on that, but I think it was Judge Niemeyer. It's hard to recognize the voices right there. The Judge Niemeyer, I believe, it said, well, then that means the burden's on the government to show that these guns are dangerous and unusual and not in common use, and that's on the government, and that's what the government has to do, and the government hasn't done it yet. So that's actually was quite interesting. Now, the Maryland attorney tried to convert, as you know, tried to elevate every single controversy and issue involving the Second Amendment to the plain text level. In fact, the lawyer for Maryland was called out on that. One of the judges says, wait a minute, the in common use test, you want to be part of the plain text, but you're simply trying to put everything into the plain text before the burden shifts to the government. So one lawyer actually caught on and got that right. The other interesting that the Maryland attorney said is that he was asked a couple hypotheticals about self-defense by the court, and he actually indicated he thought that the only place that an AR-15 should be in the home, if it's properly in the home, should be stored in a safe, and that a handgun is the best self-defense for the home, which is really ironic. And we talked about this on the channel before because, I'm a student of history, especially Second Amendment related history. If you go back to 2008 and the Heller argument before the Supreme Court, the anti-gun movement in America was arguing that long guns were good, shotguns were good, rifles were good for self-defense, and handguns, the preferred weapon of criminals, was bad. And therefore, DC's gun ban of handguns was legal under the Second Amendment. Now that the Heller case has come out and said that handguns are protected arms under the Second Amendment, now we're seeing these arguments made by like Maryland today that's basically saying that handguns are good and rifles are bad. Handguns are good for self-defense. Rifles are not suitable for self-defense. So it's ironic how since 2008, because again, it just goes back to show you these governments just want to ban guns, starting any way they can and get to the ultimate goal. But there was a big discussion there about the suitability of guns. But as you know, the right answer when people talk about the suitability of firearms for self-defense or for any lawful purpose, the answer is the government doesn't get to decide. The Second Amendment says that we have a right to all bearable arms, and then unless there's a historical tradition of some sort of regulation or ban or whatever it is, which is very few, we the people get to decide what arms that we own, that we use. We decide, not they, the government. And that is clearly something that most of the judges today in the Fourth Circuit did not appreciate, that we, the people, decide what arms we want to use. They, the people on high, surrounded by guns with the U.S. Marshal Service, don't get to make that decision, nor do politicians surrounded by armed security get to make that decision for we, the people. That's not how it works. But let me carry on. Another thing that we saw is the judges clearly were very sloppy in their reasoning. They're talking about a long history of gun regulations going back to even references to England, as I recall, going back to even before the founding of this country. Now, of course, this is the key distinction. They keep using the word regulations, regulated, right? What is the one word that you did not hear them use? That would be a history of gun bans. But what Maryland has done here is a gun ban of some of the most popular firearms in America today. It is a ban. But if you go back, there may be some argument about regulation, about can you carry it open, can you carry it concealed, things like that are about regulating the gun or regulating the use of the gun. You can't shoot a gun in the middle of Times Square into the air for fun at noon. Those are sort of regulations of the use of the gun in certain respects. That is some historical tradition you can have that debate about at least, but none of those regulations are bans. And that's the key distinction. And that's why the Supreme Court said that if an arm is in common use by Americans for lawful purposes, including but not limited to self-defense, it cannot be banned because it's consistent with both the dangerous, bans on the carrying of dangerous and unusual weapons, as well as the tradition in America, the historical tradition of people bringing commonly owned firearms with them to militia musters. That's kind of what the gestalt of what Heller said. The bottom line is that the burden is on the government to show that there's a history of bans and that, these weapons, we're talking about AR-15s and magazines that hold more than 10 rounds, although the Bianchi case today did not deal with magazines. That's really what we're talking about here. But let me carry on. Now, this is another, the number of logical errors. I think if I'm going to get a transcript and play this for you separately, because some of these things are just going to make your blood boil, and I feel like your blood is probably already boiling from the Ninth Circuit argument and the Supreme Court stuff to some degree, so I didn't want to add on to it, but maybe I'll do it in my next video or so and play some of these absurd comments, because it's just absolutely absurd. So I just wanted to hit the highlights here, and then we can maybe play some of the audio tape of the argument. But then you have this sort of my feels, right? How I feel. And what does that mean? You had one judge here talk, I think it may have been Judge Wilkinson, but don't quote me on that, but we're going to double check the transcript, try to figure it out. But one judge was talking about his experience in the military using machine guns. Now, of course, okay, no one cares about your experience in the military. That doesn't tell us anything about what Americans own today or what we want to own and what we have the right to own. But he tells stories about how, and a machine was really bad and did all this stuff. It cut, crazy stuff. And I'm just thinking look, no one cares. that what you did in the military when you were a W-2 employee of the government. We have nothing against members of the military. We're pro-veteran. We're pro all of that stuff. But the reality is you cannot use your experience as a government employee, i.e. a government soldier in the military, using government service weapons given to you by the military. That doesn't speak to what we as American citizens and American civilians today want to use and need to use and feel like we want to use and believe we need to use for self-defense or other lawful purposes. They're totally irrelevant. And yet here you have this kind of like, this is how I felt, this is what I thought, and I was in the military years ago, and I'm like, dude, we don't care. We don't care. I'm sorry. Thank you for your service on behalf of the country. But this has nothing to do with the Second Amendment here in the United States of America, whatever you did overseas, even if you went overseas. Now, some of the other crazy things that came up, just to show you where this court was just so off the rails, absolutely off the rails. And I don't say that lightly, but I'm telling you it was off the rails, and I'll try to play you evidence of it, and you will believe me, I believe, okay? There was literally discussion about women at the time of the founding, whether or not they were part of the people. Why on earth, in a case as to whether or not an AR-15 is a protected arm under the text of the Second Amendment, the right of the people to keep and bear arms, why are you talking about whether or not women are protected people, as in the right of the people? Like, how does that even come up in a case involving what is an arm and what's a protected arm? So that's the sort of absurdity we saw from these judges. And by the way, this was caused by questions and comments from the judge. So it wasn't like from the lawyers bringing up this stuff, but that was from the judge. The other crazy thing is, remember, what I've taught you is, when you say to me sometimes, why do I care, Mark, about this big win in a district court in West Virginia or in Alabama or something, like, why do we care? And then I try to explain to you, every case that we win is a brick in the wall, another brick, another brick, and another brick, because each of these legal precedents can then in turn be used, if they're in favor of the Second Amendment, they can be used by other judges to make decisions in favor of the Second Amendment. So each legal precedent that's favorable to us is another brick that other people can use to continue to build the wall to protect our right to keep and bear arms, and for all of our, and protect all our constitutional rights and the Constitution itself and the country itself, right? But here's a perfect example of how it works against us. And what I mean by that is there was multiple references by these judges, and this is what's pathetic in a different way. These judges, Court of Appeal judges sitting en banc, which means all the active judges in the United States Court of Appeals for the Fourth Circuit is sitting en banc hearing this case about AR-15s, and you know what they're talking about? I kid you not. They're literally talking about a single United States District Court decision out of California, the Rupp case. Just recently, I don't think they said Rupp, but they were referring to Rupp because they said a Central District of California case from last week talking about how that ruled against the Second Amendment and that, ARs are not protected arms, and they talk all about that. Now, how pathetic is it that you have a U.S. Court of Appeals, Federal Appeals Court, is citing and talking about a district court decision from the Central District of California, but conveniently is not talking about all that whole host of decisions from Judge Benitez, which is far more intellectually honest and consistent, in my opinion, with Supreme Court precedent and the text of the Second Amendment than that one-off decision by the one zany anti-gun judge in the Rupp case. And yet the Fourth Circuit decides to glom on to the Rupp case that, of course, it goes against the Second Amendment. And this just illustrates how judges use these other decisions to advance either the rule of law or, in the case, in my opinion, of the anti-Second Amendment movement, to advance gun control in violation of the rule of law, in violation of the Constitution. But again, it's an example how other judges use the work of other judges, and that's why when I say something is significant, it's significant because I can see down the chessboard how it can possibly be used by lawyers in other cases across this country to defend our rights. And last but not least, our favorite friend, which I brought up before, they talk about these AR-15s are a new technology. It's like something unprecedented, the same old stuff. They try to use that language out of Bruin, which we've talked about how that's being used out of context by courts like the Fourth Circuit, apparently. The reference to unprecedented societal and unprecedented technological change referenced in Bruin is specifically saying that in future cases other than Heller, which is an arms ban case and set forth the constitutional standard for an arms ban case, and Bruin, which deals with discretionary licensing regimes, in cases other than those, well, you might have to use more loose historical analogs because of unprecedented societal or technological changes. But they specifically carve out and say unequivocally that that language cannot be used to rewrite or write over or redo the Heller decision, which said if you're dealing with an arms ban case, because Heller was a ban of handguns by the District of Columbia, you apply the constitutional test given to us by American history of in common use, because if an arm is in common use, it cannot be dangerous and unusual, because if it's in common use, it cannot be unusual and thus cannot be dangerous and unusual, because that conjunctive test cannot be met by the government who bears the burden of showing that something is dangerous and unusual to even have a chance to ban that particular item. And when you're dealing with AR-15s and magazines that hold more than 15 rounds or more than 10 rounds, these are so ubiquitous. They're everywhere. There's tens of millions of these when it comes to the semi-automatic rifles. There's hundreds of millions of magazines. They're everywhere, which is why the anti-gunners complain about them being everywhere. And yet we get to court, they're like, oh, they're not in common use. Of course, what's going on here is the gun controllers are trying to elevate the in common use test to the plain text and say that the burden of proof is on the Second Amendment plaintiffs to show that these arms are in common use for self-defense by showing that people use AR-15s and magazines every day to pull triggers to kill bad guys. But of course, that's not how it works, because the burden is, first of all, the burden is on the government to show they're not in common use, number one. And number two, use extends to all lawful purposes, not just self-defense. And of course, number three is just by carrying a gun every day, I'm using that gun for self-defense. Whether or not I pull the trigger, I'm still using the gun in the same way that I use life insurance policies, or I use homeowners insurance policies, or I use auto insurance policies, or I use the fire extinguisher in the other room in case a fire breaks out. These are all items being used, whether or not I need to put in a claim on a policy for insurance, or I actually pull the trigger for for a fire extinguisher, or I pull a trigger for a gun. They're all still being used for a purpose, even if you don't pull that trigger. Of course, that's not what the gun control movement in America wants these courts to find. And when it comes to the Fourth Circuit, I'm sure they will do absolutely everything terrible, wrong, and inconsistent, which is why I hope the U.S. Supreme Court steps up and grants cert in this Bianchi case right here and right now, and takes this case away from these jokers in the United States Court of Appeals for the Fourth Circuit. And by jokers, I mean most of the ones that I talked, there's a few exceptions there that actually seem to know what they're doing. But overall, the gestalt, I would say, was absolutely terrible, just as I predicted. So there you have it. All right, folks, hope you learned something here today at the Four Boxes Darn. Make sure you check your subscription and make sure you're subscribed. We're trying to get to 150,000 subscribers. We're way behind everyone else. Don't know why that is. Don't know if people are getting knocked off. I have no idea, but I'd appreciate your support. Don't forget to follow me on X at Four Boxes Diner, where I tweeted out and live tweeted quite a few comments about the oral argument. So catch me there for more information about the Second Amendment. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.